Welcome to Deep Dive. Today we're pulling back the curtain on a really significant policy shift by USCIS, one that's sending ripples of concern through, well, thousands of families navigating the immigration system. It's a critical change impacting how a child's age is calculated for green card eligibility. It's all about something called the Child Status Protection Act, or CSPA. Our mission here is to decode not just what this shift means, but why it matters so profoundly to your family's future.
Absolutely. And this isn't just technical legal stuff, is it? We're talking about real families. Many have waited so patiently, years, sometimes decades even, and now they're potentially facing unexpected separation, all because of these evolving timelines. We really need to get into why CSPA was created in the first place and how this new rule might just upend expectations for so many.
Okay, let's unpack that. What exactly is this age-out problem CSPA was meant to fix? Why is it such a, heartbreaking issue?
Yeah, the core problem, it really comes down to the incredibly long processing delays in the system. It's systemic. Children of immigrants often age out. Basically, they turn 21 while their green card petition is still stuck in the backlog. And once they hit 21, boom, they're no longer considered a child for immigration. They lose eligibility for the visa their parents filed for. This affects, believe it or not, over 65,000 children every year.
65,000, wow.
Yeah. Imagine you file when your kid is 12, 13, 14. You wait, you follow the rules, and then years later they've aged out. Now they need a whole separate petition, maybe adding another decade to their wait. It splits families apart. It's devastating.
So it's really not the family's fault at all. It's the system delays causing this. What finally pushed Congress to step in with CSPA?
Exactly. It wasn't about people doing anything wrong. Before 9/11, things were different. A family petition might take, say, 2-3 years. The system was kind of built for that. But after 9/11, security concerns really slowed everything down dramatically. Wait times ballooned, 5, 8, sometimes 15, even 20 years for certain categories.
20 years, good grief.
Right, so kids who were in elementary school when the process started were suddenly graduating college, but legally, they'd lost their place in line. Congress saw this wasn't fair. They passed the CSPA in August 2002 to protect these kids. They created this mathematical formula to essentially freeze a child's age, giving them credit for the time USCIS was just sitting on the petition.
Okay, freezing the age sounds like a lifeline. But I suspect it's not quite that simple. Are there complications?
Yeah.
Deadlines, maybe?
You're right to be suspicious. It's definitely not as straightforward as it sounds. First, you have to figure out the child's actual biological age on the exact date an immigrant visa becomes available for their specific category. And that date, that availability, it's determined by the State Department's monthly visa bulletin. We'll need to talk more about that.
Okay.
Then, from that biological age, you subtract the number of days the initial petition, the I-130 or I-140, was pending with USCIS. If the number you get, the CSPA age, is under 21, then yes, they're still considered a child.
Okay, that makes sense. Calculation needed, but it sounds like a clear formula. But you mentioned complications. Is there a catch? A sort of gotcha?
There is, and it's a big one. It's called the sought-to-acquire requirement. This means the child must take concrete steps towards getting their green card within 1 year of that visa becoming available. 1 single year.
What kind of steps?
Well, if they're in the U.S., it usually means filing the main green card application, the Form I-485. If they're overseas, it's submitting the online immigrant visa application, the DS-260. But here's the kicker. Miss that 1-year deadline, even by a single day, and poof, the CSPA protection just vanishes, like it never existed.
Wow, that's incredibly strict. 1 day.
It's incredibly unforgiving, yeah.
Okay, now let's shift to the big news, the reason we're diving deep today.
Yeah.
This August 2025 rule change. What exactly is USCIS changing, and what's their reason for it?
Right. So starting August 15, 2025, USCIS is going back to a stricter policy for calculating that CST age, specifically for people applying for adjustment of status from within the U.S. They announced they will now only use the final action dates chart from the visa bulletin. This actually ends a more generous kind of temporary policy that they had in place since February 14, 2023. That policy sometimes allowed using the other chart, the dates for filing chart.
And their reasoning?
They say it's about consistency. The Department of State, for people processing visas overseas, already uses the final action dates. So USCIS says this new policy just lines everyone up inside or outside the U.S. using the same standard.
Okay, consistency. And just so everyone listening is clear, this hits applications filed on or after August 15, 2025, right?
That's correct. If you filed your adjustment application between February 14th, 2023 and August 15th, 2025, USCIS has said they'll honor the old, more lenient rules using potentially either chart.
Good to know.
But after that date, August 15th, 2025, it's the stricter final action dates chart for everyone applying for adjustment.
This brings us to a really critical point then. What is the difference between these two charts, final action dates and dates for filing? Why does it matter so much which one they use for the CSPA age?
That's the million-dollar question here. The Visa Bulletin, which the State Department puts out every month, it's like the roadmap for green card availability. It tells you if you can move forward based on your priority date, basically, when your initial case was filed. Think of it like a queue, maybe for a popular concert.
Okay.
Now, imagine two lines for that concert. Final action dates, Chart A. This is the line that tells you when you can actually get in, when your green card can be issued, your application approved. If your date is current here, a visa is ready, you're getting into the show. Dates for filing, Chart B. This was the more generous line used sometimes under the temporary policy. It let you get in line early, file your I-485 adjustment application, or submit documents overseas, even if a visa wasn't actually ready for final approval yet.
Ah, so like getting closer to the stage but not actually in yet?
Exactly, you could get in the queue sooner. And crucially, those dates for filing are often months, sometimes even years ahead of the final action dates, especially for countries with huge backlogs like India or China.
Right. And getting in line early, using those dates for filing, wasn't just about hope, was it? It came with real benefits.
Huge benefits. Filing that I-485 early, based on the dates for filing chart, meant you could also apply for a work permit, an EAD, and a travel permit, advance parole. While your green card was pending, which could still be years, you could work legally, travel internationally. That provides immense stability. Not minor perks at all.
Okay, so losing the ability to use those earlier dates for filing for the CSPA calculation, what does this actually mean on the ground for families, particularly those from, say, India, facing those massive backlogs?
It means significantly less wiggle room. And frankly, it means considerable hardship for many. You hear people say final action dates are brutal for India. And it's true. Those dates can lag years, sometimes decades, behind the dates for filing. Yes. So for children who are maybe 19, 20 years old, in those backlogged categories, we're talking employment-based EB2, EB3, many family categories. This change, using the later final action date, could easily push their calculated CSPA age over 21 before a visa number even becomes available for them. They age out simply because the goalposts moved.
Let's think about the human impact, like H-1B families maybe?
Absolutely. Think about kids who grew up here on H-4 visas, went through American schools, planning for college in the US. If they age out at 21 before the family gets the green card, they lose that H-4 status instantly. Their options become really difficult. They might have to switch to an F1 student visa just to stay and study. But doing that often means losing in-state tuition rates, losing eligibility for certain scholarships.
And losing the stability they thought they had.
Exactly. Their whole education plan can be upended. It's not just a legal shift, it's deeply emotional. We've seen comments online, people saying things like, "We filed thinking dates for filing would save our kid," or "My son turns 21 next year, this could kill his case." It's heartbreaking.
And there's a potential loss for the U.S. too, right?
A big one. You risk losing highly educated, U.S.-trained young people who might have otherwise contributed here, potentially pushing them to countries with more welcoming policies.
Okay, let's circle back to that sought-to-acquire requirement, that one-year clock. With this policy change making visa availability dates later, this requirement feels even more dangerous now, like a tripwire.
It absolutely is a bigger tripwire now. Because the date your visa becomes available under the final action chart might be much later, there's often less time between that date and the child actually turning 21. The window to act, to file that I-485 or DS-260 within 1 year becomes even more critical. And remember, miss it by one day and the CSPA protection is gone.
And you mentioned exceptions are rare.
Extremely rare. USCIS defines extraordinary circumstances very, very narrowly. We're talking about things like the child being physically unable to act, like being in a coma, or maybe serious illness or wrongful imprisonment, not, finishing final exams or needing more time to gather documents. There was a recent clarification, yes, about situations where those truly extraordinary circumstances happened during that Feb 2023 temporary policy period. In that specific scenario, they might still use the earlier date.
But for most people.
For the vast majority listening, the message has to be, Do not count on exceptions. That 1-year deadline is effectively absolute. Vigilance is key.
Given all this complexity, the high stakes,
Mhm.
are there any, I don't know, secret weapons, strategies families might not know about to try and protect their children? What can people do proactively?
Yes. Thankfully, there are a few advanced strategies. They require careful planning, often years in advance, but they can make a huge difference. First, there's something called cross-chargeability. It's powerful, but often missed. If one parent was born in a country with a shorter visa backlog, the child might be able to charge their visa to that parent's country of birth, essentially jumping queues.
Can you give an example?
Sure. Say you have a family where both parents were born in India, which has long waits, but maybe one parent was actually born in, say, Canada before moving to India. That child might be able to use the Canadian visa quota, which could potentially cut their wait time by a decade or even more compared to the Indian queue.
Wow. But you have to set that up early.
Right from the start. When the initial petition is filed, it's not something you can easily switch later. Good legal advice is crucial here.
Yeah, what else?
Second is strategic naturalization timing. This applies to parents who are already permanent residents, LPRs. Sometimes the parent becoming a U.S. citizen can actually move their child into a faster family-based category, but the timing has to be perfect. Usually the sweet spot is becoming a citizen just before the child's original priority date becomes current in the visa bulletin. But after you've done the CSPA calculation and confirmed, they'll still be protected as under 21.
So too early is bad, too late is bad.
Exactly. Naturalize too early, and you might shift them to a category that, counterintuitively, has a longer wait. Too late, and you miss the opportunity. It requires precise calculation and understanding of the visa bulletin's movements.
Complex stuff. Okay, what if those strategies aren't possible, or they don't work out, and a child sadly does age out? Are there any last resort options?
It's tough when CSPA fails, but there are sometimes other avenues, though they are often more difficult. One is humanitarian reinstatement. If, tragically, the parent who filed the petition passes away while the case is still pending, USCIS does have the discretion to reinstate the petition based on humanitarian factors. It's a somber thought, but it's an option.
Okay.
Then there are alternative visa categories. The now adult child might qualify for a visa on their own, maybe an employment-based visa through their own job offer, or continuing as an F1 student, which could eventually lead to work authorization, or perhaps even investment visas if the family has significant resources. The goal becomes maintaining legal status here while pursuing a green card through a different path.
Any hope from Congress?
Well, there are currently, I believe, 3 different bills floating around Congress aimed at expanding CSPA protections, fixing some of these issues. But, legislative fixes are usually very slow, very uncertain. It's definitely not something families can rely on happening quickly, if at all.
Right. So, wrapping this up, this deep dive really underscores that this USCIS policy shift back to using only final action dates for CSPA is a major change. It's going to have a deep impact, especially on families from backlog countries like India. For you listening, understanding that crucial difference between the charts, being hyper-aware of that unforgiving sought-to-acquire deadline, and maybe exploring those advanced strategies like cross-chargeability or time naturalization, these are more critical now than ever to protect your family.
Absolutely. And this situation, it really highlights a bigger tension we always see in the immigration system, doesn't it? The push and pull between control measures and the need to support families, many of whom are contributing so much here. It makes you think about the long-term consequences on talent retention, on education, and just on the basic principle of keeping families together.
Yeah.
Beneath every policy tweak, there are real lives, real futures hanging in the balance.
A very important point. We really hope this discussion has given you some valuable, maybe actionable insights into what is undoubtedly a complex and sensitive issue. All the best, and we will meet again with another important matter.